everyone. Welcome to our webinar today, Life's Potential Pinch Points and How to Best Cope. So in this panel session, we'll follow the journey of a young person about to embark on her career through her different life moments through to her retirement. So our panelists will discuss life's typical pinch points where proactive financial and legal guidance could help make you or indeed your family more resilient to anything life may throw at you. So my name's Karen McKinney. I'm the marketing director at MHA Carpenter Box, a firm of chartered accountants, tax and business advisors. I'll let the panel introduce themselves. I'll start with my colleague, Jill Lyons.
Hi, Kira. So I'm Jill Lyons. I'm Senior Financial Planner for MHA Carpenter Box Financial Advisors. I've worked for Carpenter Box now for 5 years, but I've been in the industry since the mid-80s by regret. So I advise on all parts of financial advice, but I guess my specialities are later life care. I'm a member of the Society of Later Life Advisors.
Great. And Sarah?
My name's Sarah Pennicott. I am an associate solicitor at Bennett Griffin Solicitors, and I practice family law. So I cover all aspects of relationship breakdowns, forming relationships, children, all of those issues. So I qualified in 2005 and I joined Bennett Griffin last September. I'm a member of Resolution, who are a group of family solicitors trying to resolve things amicably and constructively. And a member of the family law panel.
And Gemma.
Good morning, my name is Gemma West. I am an associate solicitor at Bennett Griffin. I head up the Wills and Lasting Powers of Attorney department. Wills and Powers of Attorney are my specialism, but I have worked in all areas of private clients. I started at Bennett Griffin in 2016, and I've been working in private client, I think, since about 2013-14. Prior to that, I did family law for about 10 years, but I'm moving next.
With that, let's meet our plucky young protagonist, Jane Jones. We're going to be following her throughout her life. So we start off with Jane, and she's 21, so she's a recent graduate. She's graduated from university and quite recently. So she has around £30,000 in student loans that she will have to consider. So she's just started a job in sales, so high earning potential, but she's on a lower salary to begin with, and is renting a flat with her friend. So this is a sort of starting scenario for her. So Jill, I'll start with you. What are the important issues that Jane should consider financially at this early stage?
So I think Jane really needs to think about what benefits her employer offers her. So if they offer an automatic enrolment pension, I've met a lot of people who are young who say, well, you know, it's not worth it. I don't want to join the pension scheme. But what they don't realise is that the younger you start saving for pensions, the less you have to put in later years, because you've had the benefit of years of growth. If you're lucky enough when you've joined an employer and they offer you some kind of health benefits, so some kind of death in service perhaps, which is a form of life cover, or some income protection, to take advantage of those things that are offered to you, but to make sure when you have something like life cover offered to you that you nominate the correct beneficiary, and you also keep an eye on the beneficiary that you've nominated. So for example, death in service very commonly gives you a measure of protection which is based on the salary that you earn. So it might be that your life cover is 4 times your salary. So if you earn £20,000, you might get £80,000 if you were to pass away whilst employed. So when you first start out, you probably are going to nominate your parents or a sibling. But as time goes by and you have a partner or perhaps children, you'd want to keep an eye on that nomination of beneficiaries and change it. The same goes for your pension. So when you start out in automatic enrolment, you would be nominating somebody to receive those savings that you've accrued whilst you're working. So it's important to make sure that as a bit of life admin, that you still want the people that you've nominated to continue to have those benefits if anything happens to you. So I think that's a basic when you're starting out, just get those things in place and just keep an eye on them as you go on.
Okay. And what about from the legal side?
The only thing is, obviously, at the moment, she doesn't have any assets, but thinking in the future when she does start building up some assets, it's to think who she would like to leave those to, and the best way to ensure that she does leave who she wants to is to have a will. So then you're appointing people as executors who she trusts to be able to deal with her estate, and then she can leave whatever estate she has to beneficiaries who will be able to inherit.
That actually leads me, it's a little bit early, but I'm going to pop it out there anyway. Speaking of wills, do you have a will? We had some people earlier on in their career, see whether or not they've taken advice. I would hope possibly if they were closer to retirement, it's been a consideration, but we'll see. All right. Ooh, pretty even. We're about 50-50, but tipping into the no. Ooh. I would imagine advice, for those watching that don't have one yet.
I think the problem is, like, when we talk a bit further along, is people don't realise that if they're not married, they don't necessarily inherit, or even if you are married, you don't, if you haven't made a will, necessarily inherit the whole of the estate or the deceased spouse. So it is important as well, and it is easier from an estate point of view as well. By having a will, you appoint people you trust to be able to deal with your affairs, and you also ensure that people benefit from your will who you want to, because it could be that someone you don't want to may inherit under the intestacy rules. So,
yeah.
All right. I'm sure we'll get to that in a little bit. Sarah, anything else that you want to add?
Not from a family point of view. If she's single at that point, there wouldn't be any sort of considerations from a family point of view.
So if we move a few years along then, so Jane's doing quite well in her business. She's been promoted several times, and she's now actually considering possibly starting a business of her own. How can Jane benefit from advice as her career progresses?
So I think from my point of view, it's important to get into a good habit of savings. And, so if she's thinking about starting her own business, what impact's that going to have on her finances? So coming from a salary point of view, if you're in employment, you'd expect those benefits to be provided for you. So if you have a pension, then that's provided for you and organised for you. If you have life cover through work, that's done for you. Income protection, so some form of sickness protection if you're unable to work, that's all done for you. So everything is provided, and also your PAYE normally, so you don't have to think about a tax return or anything like that. So when you're starting up a business, from a financial planning point of view, it's important to think about how your business can help support you. So is it possible to arrange life cover through your business to protect your family if anything happens to you? Is it possible to arrange some form of income protection? Because starting a business is a scary time. Everything depends on you. If you're unable to continue to work, what provisions are there in place to make sure that you've still got some money coming in to support you? And I think it's also important, I think throughout this, I'm going to harp on about budget. So to understand what your base level of costs are. So what do you need to be bringing in to support heating and eating? So to keep the lights on and to make sure that you can survive. And having done that, off you go, into the future. I think from my point of view, those are the basic fundamentals.
Yeah, I mean, from a legal perspective, it's thinking of what happens to the business if you pass away. So it depends what type of business you have and how it's set up when you're arranging the business as to what happens. You might have a partnership, or you could have a limited company. And so it's dealing with when you're setting up the business, what does the partnership agreement say? or what does the Articles of Association say, or what the shareholders agreement say? If you pass away, what happens to those shares? If the business documents don't have those details, then it's considering, you know, you can leave those in your will if you've got shares that can pass down to your family. If you've had a business for a few years now, then you might be entitled to the business property relief as well, which is somewhere, you know, further down the line. If you are, you would obviously give financial advice first, and then if your business is entitled to the business property relief, then you can include particular trust in your will, which will ring-fence that relief, which means the beneficiaries who aren't exempt for inheritance tax reasons will be able to pass it to different beneficiaries, and then the person who would be exempt, i.e. your spouse, they'll be able to get the income from that business. So it's just thinking ahead and making sure you have things in place. It's the same if you're living but you lose capacity, whether there's anything in the partnership agreement, what would happen if one of you were in an accident, or the same with the limited company, if you're, you know, the higher shareholder or director, what will happen if you lose capacity? Is there anything in the business documents that will allow someone else to take over? If not, then you can do a business lasting power of attorney, which is something to think about. But you always have to refer back to the company documents first to see what the structure of the company is.
Can't really do till a bit further down the line, but you've got to be thinking about it when you first set up.
Yeah. Starts, you mean to go on? Yeah.
Constant reviewing.
Great. So so Jane's now started her own business and it's going quite well, and she's met someone and they're thinking about purchasing their first home together. They're not planning on getting married yet. That might come further down the line. So I'm just going to run a quick poll again. This is our last one, but just to see thoughts out there. So let me pop that up. So how long does an unmarried couple have to live together before they're what is sort of known as common law marriage? You think just a year, at least a year, at least 3 years, at least 5 years? It happens automatically. So if you're a couple and you live together, you are de facto in a common law marriage, or none of the above. Let's give another couple seconds to see what people think. In the poll there. So let's show the results. 60% say none of the above. 20% think as long as at least a year, and we've got another 20% thinking at least 5 years. Sarah?
Well, that was quite an encouraging response in some ways, because it is a massive misconception that there is such a thing as common law spouse. It was actually abolished in 1753, but for some reason it's stuck around, and people still seem to think that it exists. But without marriage, you don't ever get any of the rights that you would by getting married. So you don't have any enhanced property rights above and beyond what you would if you just bought with a friend. So it's really important at the outset of her relationship that Jane thinks about how she wants to own this property. If her business is doing well and she's contributing more to the purchase price of the property, does she want to protect her interest? How is she going to own the property? There's 2 ways to own a property. They could either be joint tenants or tenants in common. And if they're unequal shares, often it will be tenants in common, and she would protect her position by a declaration of trust, which sets out exactly what would happen in the event that the relationship breaks down and who gets what from the property. So it is really important to think about those things at the outset, rather than going ahead and not discussing it with your partner until or if things go wrong, and you need to be resolving who gets what. And I think the other thing as well is more and more people are receiving gifts from family members. And I see from the other end of it, where it hasn't been set out clearly at the outset, it's a lot more difficult to establish whether it was a loan or a gift. And if it was a gift, was it a gift to one person, or was it a gift to the two as a couple? But if those things are set out properly at the outset, then it shows the intention of the parties, and there's a lot less likely to be a dispute if things go wrong.
Would that be as simple as just putting it into writing? This is what I want the money to be, who I want the money to go to, and what I want it to be used for, or it's a gift, or I expect repayment? Would that be sufficient?
It would be better than nothing. I think the best thing to do would be to get it properly drawn up in a deed document as a declaration of trust.
Right.
Equally, people may want to think about living together agreements, which would set out if so maybe one person makes a big contribution at the outset, but whilst they're living together, circumstances change and children may come along, and factoring in all those things, whether you review the agreement at that stage or whether that changes the terms of the agreement, or if one person makes a big capital payment because they've received inheritance, would that affect how the proceeds are split at the end? But it might be that those events just trigger a review, so you then create another document. But it's really important that both of you know what your intentions are in terms of how is this property held, and if we're contributing, are we getting an interest in the property, or is it just because we're being nice people?
Yeah, I think it's just also reiterating that anything that a couple hold jointly does pass by survivorship. So if you do own a property and decide to hold it as tenants in common, you might set up a joint account as well. So with the bills are paid, so on passing, one of them passes away, that account will automatically pass to the survivor of them. And they should also think about that if one of them did pass away, what happens to the deceased share. So if they are holding it as tenants in common, one of them may have made a will and left their share to any equity potentially to a parent or a sibling, then does the survivor of them then have to sell the property in order to realise the estate from the deceased? So it's always thinking worst case scenarios, although it's a lovely thing buying, purchasing a property key and it's all happy. You should think about, one of you do have an accident and something happens to you, that you both discuss what's going to happen to the property. Because initially, if you're first time buyers, you're not going to have much equity, and whether the survivor of you want them to stay in the property for at least a period of time so they can sort themselves out financially. Jill already talked about life insurance to cover the mortgage if one of them dies. But it is thinking of those case scenarios, because if you don't leave a will, as we know, there's no such thing as a common law partner. So it would be falling under the intestacy rules. So if under the intestacy rules, it would be the parents that would inherit. So it's thinking about those case scenarios.
Yeah, and I'd coming back to the life insurance part. It's very common to take life cover over a mortgage. Should you be thinking really about having the life cover held separately? Because if it's joint life cover and it pays out on the first death, then the surviving party then has to start again with another policy, or if the couple splits up, you have to start again with a new policy. So is it better to start at the outset and have individual life cover? Is it a good idea to have some kind of form again of income protection, which will kick in if you're not able to work, so that your share of the mortgage or the bills can continue to be paid? And I think at the outset of starting a relationship, it's really important to have an honest conversation about expectations as to who will pay for what. So if there's inequality in earnings and a disparity between one person perhaps being paid large bonuses and a large salary, the other person perhaps being paid a more steady wage, what's the expectation of who will pay for what? Are you going to have a joint account and use that as a bills account? Are you aware that you're jointly and severally liable for joint debt? So if one person loses their employment, the other person will be expected to carry the weight of that debt. And that's an important thing to understand as well.
So Jane and her partner have now decided to try and start for a family. So they've now got children. What are the next steps that they both need to be considering?
I think from my point of view, it's family cover again, so protection of the family, to understand that, you know, if one partner is to pass away, then you want to be able to support the family to continue to live, presumably in the home that they've always had, so there's no more disruption. The other thing, you know, less morbid perhaps, is to think about savings for children, to have a look and see what's available. Could you start an ISA for them? Could you start a pension for them? A lot of people don't realise that children can have a pension, so you could contribute up to £3,600 annually to a pension. So it's those things to start thinking about. And also, if one party has given up work or reduced hours to look after children, what happens then with child benefits? If one party is a higher earner and that child benefit is lost, a lot of people think that's an automatic thing, whereas it isn't. The partner who is looking after the children and taking that child benefit could continue to do so, whereas the higher earning party could simply pay a tax charge. And a lot of people won't realise that and just take it as an automatic, whereas it isn't. So
I think from my point of view, it would be one of the truths. So if Jane had entered into a living together arrangement or a declaration of trust, it's the time to review those documents and see whether the commitment of children and the change that brings to their income means that there should be a change to the agreement that they've already reached, because these things are final, they just show an intention, and you can keep reviewing them and changing the arrangement if the situation changes, and it's fair to do so. And you agree?
Yeah.
Yeah.
Absolutely.
From my perspective, it's just thinking that if you have young children, if you pass away, who would look after them, or, you know, considering about appointment of guardianship, it doesn't necessarily mean that the children will live with that guardian. So you can have one from each side of the family, but they discuss and consider matters such as education and religion, and all aspects like that. So it's just keeping on top and thinking, you know, worst case scenario, who would be able to look after the children or have a say in their upbringing.
I wanted to ask, you mentioned reducing hours. A lot of parents do that. You know, we're currently still in the pandemic. A lot of people have reduced hours or been asked to reduce hours. What impact does that have on their pension, on their national insurance contributions? What do they need to consider?
Yeah, so a lot of people don't realise that these days you need 35 years of national insurance contributions to benefit from a full state pension. You need at least 10 years contributions to qualify for any state pension. If you reduce your hours down, necessarily that's going to have an effect on your earnings at retirement. So it's quite important to keep abreast of that, and to make sure that you understand when you're going to receive your state pension and how much it will be. And you can do that by going to Gov.uk and checking. You can fill out a form online. We call it's a BR19 form. You can do that and make sure that you know exactly what you're entitled to. You can also check online your national insurance contributions and make sure that they're up to date. And it's possible to purchase missing years. But this comes back again to child benefit, because child benefit, for if you have children under 12 and you're receiving that, helps towards your national insurance contributions. So it's not always the right thing to do for one partner to say, well, okay, I'm earning too much and we accept this fact, that we're not going to receive that benefit. Sometimes you just need to look at that a bit closer. But yes, it does have an impact. So reduction of hours, does have an impact on your pension savings. If you're saving through work, and automatic enrolment, the less you earn, the less goes into a pension, and it's something you need to keep an eye on and perhaps make up in later years.
Next question, if Jane's sister has entered into a marriage, to somebody who already has children from a previous marriage, how does that affect? Yeah.
So it's something that Sarah touched on previous, where you can hold the property as tenants in common. So if you're getting, you're in a new relationship and you're going to be putting your assets together, so to speak, you could, and you've both got children from previous marriages, relationships, and we call it a blended family. So you could purchase the property as tenants in common, and if you are placing different portions of equity into the property, then you can have the declaration of trust to confirm that. In your will, what you can do is include what's called life interest trust in your will. So effectively, you both own different parts of the property. So if husband or partner dies, then he can leave his share to his children, and the same for wife. If she dies, she can leave her share to her children. And what happens is it will be set so you're kind of preserving the capital. So if husband dies, you're preserving the capital for his children, but the survivor of them can remain living in the property for their lifetime. And so they both have the benefit of living in the capital, but it's always preserved for their respective children in the future. So you know that if you ever find another partner in the future, your capital will always pass down to your blood children. You can do that for property. If you wanted to, you can do it for other assets or the whole residuary estate if you wanted to. But generally, because the majority of capital is in the property, clients tend to do it as life interest trust over the property, and then sometimes other assets they'll just leave to each other because they're building up assets during their lifetime.
I think from my perspective, if you're both coming to the marriage with assets already and also then children from other relationships, they would probably want to think about a prenuptial agreement, because although they're not entirely binding, they are carrying more and more weight with the court, and unless it's unfair to follow it, generally, as long as the right procedure has been followed in preparing that document, the courts will uphold it. And obviously, if Jane's sister is in a new relationship, she may want to keep her property, as Gemma says, for her children going forwards, but without a prenuptial agreement, in the event that that relationship breaks down, the whole of their assets could be taken into account, and she may feel like she's losing what she otherwise could have preserved.
That leads us to the next point, is if Jane and her spouse then do decide to divorce, and if theirs is again perhaps not a blended family, but it's just Jane, her spouse, and their children, what financial advice or legal advice would she need in preparing to leave that relationship?
So in terms of the advice we'd give her, it would depend what she'd done at the outset to protect her position, because if she had entered a prenuptial agreement, it may be as simple as they both agree that that's what's going to happen. They're going to follow that prenuptial agreement, and then we formalise the agreement in an order that they agree, that is submitted to the court by consent. Equally, it may be an amicable split whereby they agree, even though they didn't agree in advance, they agree when they separate how they're going to divide the assets. But it's really important that that is formalised by the court in an order, because it will only become 100% binding once it has been approved by the court in an order, and their financial claims for against each other will only be dismissed once the judge has formally done that within a court order. So lots of times we see people saying, well, we agreed 5 years ago, and now this person wants to come back for more, and that claim is still open to them because it hasn't been properly dealt with at the time that they reached that agreement, or they thought they reached the agreement.
From my point of view, I see people who are at the point of divorcing or considering divorcing, and it's really, really common. I think you probably see this, Sarah, where one party will say, well, okay, you keep the matrimonial home, it's most commonly the woman, and the husband will say, well, I'll keep all my pensions. And that, you know, on the face of it can seem like a really nice, clean, clear settlement. But I think it wants a lot closer inspection and discussion and analysis, because although at the time, you know, the matrimonial home carries a lot of sentiment and may be worth a lot of money, you still do need income to support your lifestyle when you're in that matrimonial home. And this is where we've spoken about maybe issues not always affecting women, but commonly affecting women who have gone part-time to look after children, or maybe given up their jobs. At the point of divorce, the matrimonial home is a huge part of some stability, but you're going to need income going forwards, and the value of those pensions may be colossal. So, you know, I had a client very recently, he said to me, oh, I don't want to get into pensions, it's too complicated. Her partner had 3 or 4 pensions, and 2 of them at least were defined benefit pensions. So the value of those may or may not have been huge to her. So it's something that we see more and more often. People really do need to investigate that. I think there's some other things, other bits of good housekeeping. If you're separating for your partner financially, you need to look at those arrangements that you've already made. So look at those life policies that you have. Do you still want to nominate your ex-spouse to have those benefits? You may want to, because the children, if you die, he will be looking after them. You may think it's perfectly valid, but for that benefit to still be paid. Or you may think, well, actually, no, I don't want that. That's not appropriate. Do you still want money built up in your pension funds to go to your ex-spouse, if that's who you've, or partner, if that's who you've nominated? The other thing I feel is quite important is debt, you know, and that's something that it isn't always considered. And that I hadn't realised, and I think a lot of people don't realise, is that it's possible to disassociate yourself from your ex-partner on your credit reference records. Because if you're then completely reorganising your life and looking at taking on perhaps more borrowing, taking on a mortgage, credit reference agencies will look at the behaviour of both of you, where it's jointly held debt or jointly held assets such as a joint bank account. So if you, commonly there's one spender and one saver in a relationship. If you had a partner who had some debt and perhaps weren't managing their finances rightly or wrongly, the credit reference agencies will look at this. So that's something that you can do as well as part of the good housekeeping, making sure you know what your budget is, making sure arrangements that you've got in place continue to remain valid. You can also look at your credit reports and make sure that there are no associations that you didn't want to be there or continue to be there, and to correct that. So I think that's, you know, things you may not necessarily have thought of, still really important if there's a relationship breakdown.
Yeah, in terms of wills, obviously, they should be reviewed up until Sarah's sorted out finances with their clean break order. The spouses have entitlement to make a claim against each other's estate. So if you make sure you tidy everything up in your divorce proceedings and make sure you've got a financial order, which is clean break, so the survivor or whoever party doesn't have a claim on each other's estate. And it's just kind of potentially thinking of who else should benefit and updating any pension nomination forms to make sure that the surviving spouse doesn't inherit if you're going through separation, especially obviously everything's open and up until you finalise the divorce proceedings, but it's kind of, you know, during that time, if you've already got a will leaving the estate to each other, you want to make sure that you've changed that.
The next phase, Jane is reaching her retirement age and she's making plans for what she wants to do. Her mortgage has been paid off and she's thinking about her next plans after she finishes work. What should she be considering preparing for retirement?
So I think she needs to know what to expect. So I think that's the most important thing that I'd have to say, is to know what to expect and when to expect it, so that you can plan accordingly. You know, I see a lot of clients who are, for want of a better word, in the dark about how much they could hope to have at retirement. And sometimes it's a pleasant surprise and sometimes it's a nasty shock. So, you know, I would hope that people have been planning for retirement all along, but I do think it's important to know where to go to find that information. So there's a lot of help on gov.uk. You know, you can make sure that you know when you'll receive your state pension, because that is a large part and underpins for a lot of people their financial outgoings. You can make sure your national insurance record is up to date. You can also search for any pensions that are missing. So if Jane has had multiple jobs with multiple employers, it's possible that she may have many different pension pots. There's a lot been spoken in the past about having a pensions dashboard, so that in your working life, your pension would be tied to your national insurance number and you wouldn't end up having to start a new pot with each employer. For whatever reason, that hasn't got off the ground. So it's not uncommon for me to see people with maybe 6 or 7 pensions. And as time goes on, because of automatic enrolment, that will only become more common. I'm thinking of myself. I have 4 different pension pots. If I was thinking about retiring, I would be looking at those and looking to want to consolidate them so that I have a coherent investment strategy. And I would also want to do some cash flow planning so that I would know what kind of level of income sustainably that pot of money could be expected to sensibly support. And then I'd be making my plans accordingly. I'd know I would cut my coat according to my cloth, and know what I could expect to do. Yeah.
From our perspective, it's lifetime planning. So you're thinking ahead on what the future may hold in terms of care. So there's kind of 2 elements. Again, you've got the will situation, where if one of you pass away, will the survivor of you need to go into care? And so you can include, again, the life interest trust. So work in similar ways to blended family that I've discussed. So generally speaking, you both own the property and then you hold it as tenants in common. So husband owns half, wife owns half. Then you can ensure that your children, so if I'll kill off the wife this time, so if the wife passed away, then that half share of the property is placed into trust for the benefit, for example, of your children or your grandchildren. Then if the survivor of you needed to go into care, then the local authority would see that the survivor of you only own half the property. So they would take that into consideration. So you protected at least half the value of the property capital into trust that won't be utilised for care. Obviously, this is a trust that's in a will, so one of you would have to pass away for it to take effect. But at least you know that if anything happens, half the value of the property will pass down to your children. And there's also considerations about lasting powers of attorney. Everyone should have one of these, and they are probably one of the most important legal documents that you should have. You can have one or both types. There's the property and financial affairs lasting power of attorney, which can be used by your attorneys with your consent if you've got capacity. Then you've got the health and welfare power of attorney, which can only be used once it's registered that you have to have lost capacity. So the loss of capacity can be either temporary or permanent. So if you do have dementia, then your attorney can step in and deal with any particular care needs. Or it can be, even if you're in a coma or unconscious, then your attorney can say what treatment you should or shouldn't have. And this can relate to life-sustaining treatment as well. As soon as you're compos mentis, then your lasting power of attorney under the health and welfare would cease. So then you say what treatment you should or shouldn't have. So you can appoint initial attorneys, and then if anything happens then, you can have replacement attorneys. So these are documents that you should definitely consider, and it's something that would last during your lifetime. There is a particular process to drafting them and having them registered. But once they're registered, they're there. They're a bit like life insurance. So if you ever do need them, they're there. The worst case scenario is if you don't have them in place and something does happen to you, then your loved ones don't have access to your sole accounts or anything. And then they would have to apply to the court for what's called a deputyship application, which is extremely costly and can take quite a long time. So at least by including the lasting powers of attorney, you've appointed people you trust to deal with your health and welfare or your finances as well, rather than having someone appoint themselves as your deputyship.
So the sort of final stage that we're gonna enter in this is Jane's new partner. So she remarried, and he unfortunately is now ill and is expected is expected to die quite soon. He needs care, but there's a period where there will be a bereavement in the family. What can she do to protect herself, to protect her family, to care for her spouse that will need care quite soon?
So I think from my perspective, it's knowing what she's entitled to in the way of help. So is she able to apply for a reduction in council tax? Is she able to apply for attendance allowance? Does she qualify for that? What is her spouse's condition? What is he suffering from? Because if it's not something that requires what's known as social care, if it is an illness, so for example cancer, then she may apply. He may qualify for NHS continuing healthcare, which isn't something that lots of people are aware of or even know about. But that would mean that his care was paid for. He might get funded nursing care as well, which would cut down the cost of care. So it's not always a given that you will have to pay for care. If Jane and her husband have over 23,250, he is going to be a self-funder in most cases if it was something that needed social care, like dementia or Alzheimer's, for example. But there are things that you can do to make sure that care is paid for the long term. So it's possible to purchase what's known as an immediate care annuity or a deferred annuity. And these are policies which will pay for care for the rest of her husband's life, if that's needed. And that's something that you can look into. So there's lots of things that she may be entitled to on his behalf to help her finances. And it's just important to know where to go to find that information. And I say we've got a font of all knowledge on our website, and happy to talk through these things. But it's not always the case that you do have to pay, although in a lot of cases you will have to.
I think from a legal perspective, it is just emphasising the importance of having lasting powers of attorney in place, because you wouldn't want to be going through this process if you are poorly or diagnosed. You want to ensure that if you do have cancer, you might have a treatment where you might not be compensatory during that period of time. So it's ensuring that you have appointed people that you love and trust to be able to say what particular treatment should carry on. And powers of attorney, basically you're appointing people who you trust. The process of powers of attorney can take between, at the moment it's a bit longer with COVID, but it can take about 3 to 4 months. So you don't want to be going through that process when you're poorly and thinking what you should have in place. So it is important that you think about it, and if you put it in place, then it's something you can just put to the side. Hopefully it will never occur, but sadly it does happen. So So we can now say we never know what's around the corner. Who knew we were going to be in this situation this time last year? So yeah, it's just making sure we planned and put things in place. So if the worst case scenario does happen, you've got something that you can put out and say, I've got it ready, it's here if I need it.
I think that's the message from both of us from a legal point of view, is that just because you put these things in place doesn't mean that you think they will happen. So for me, a separation, a prenuptial or a living together arrangement, it might seem really unromantic, but at least you know you're on the same page and you've got the same common intentions. And if things don't go wrong, it doesn't matter. You almost forget about it. But if they do, you've got it set out. And it just makes things a lot more amicable at a stage which is otherwise quite difficult at the best of times.
It's like an insurance, isn't it?
Yeah.
Before we sort of wrap everything up, I'm going to go around and ask each of you if you could please tell me your top tip for building resilience in life to help cope with challenging situations. As you said, a year ago, or maybe 13 months ago, we didn't expect to be where we are now, so that those tools can be really beneficial for whatever life throws at you. So Jill, should we start with you?
So I guess my top tip would be to know where to go to get good, reliable information. So recently there's been the Martin Lewis Money Show, which did a big piece about pensions and attempted really bravely to try and speak about pensions in 22 minutes, which was always going to be a very hard task. And looking at the thread on social media afterwards, just the level of assumptions and misinformation that people thought they knew what they were entitled to, and they thought they knew what to expect, and in so many cases they were wrong or misled. So I think it's really important to know where you can get good, reliable information from, and to be able to make those plans accordingly.
Yeah, I think it is all about planning for what if and making sure that you have everything in place. And the more you're able to plan ahead, the more options you have. So sometimes when people leave it too late, they might not have as many options. So it's all a case of planning, constantly reviewing. If you look at things on a yearly basis, say, right, I've got this, I'm in this particular position now, what else can I do? It is constantly kind of, every financial year, kind of April, just kind of look, see what you've got in place, whether you need to change anything or what other options you've got available.
My advice would be with a partner to openly discuss your situation and what you think is going to happen, and make sure you've got the same common intention. Make sure you know your rights and that you put in place anything that you need to make sure that those intentions are formalized, because it's a lot easier to do it at the outset than it is at the conclusion of things if they don't go well.
Thank you for joining us. I haven't had any questions come through just now. I think that was pretty comprehensive, and we got there under an hour. So thank you so much to Jill, Sarah, and Gemma for your time. And thank you everyone for attending. Have a great afternoon.